For those of you who saw the movie, My Cousin Vinny, I'll resist the temptation to say the opening statement of the public defender in that case, which was, of course, everything that guy just said is baloney. And in fact, everything that guy just said is not baloney, and William is very well respected in this field. And I just don't want to concentrate on low dose, but I will address it originally, because I assume, well, first of all, I guess as the Chicago representative, I too want to welcome all the judges from all over the country. It's quite an array of folks, and we apologize for the snow. But Chicagoans are usually very supportive and almost messianic about our city. We are having a little problem with governors and baseball, but other than that, we're trying our best. My vision in the practical world where these cases get tried, and perhaps I should expose myself. I am an asbestos lawyer. I represent largely mesothelioma victims. I have for 25 years. But I'm so demented that I, as a plaintiff's lawyer, tried to put in plural registries for non-malignant cases under the theory that if you had this many sick people and only so many judicial resources, why don't we concentrate on the most ill, the most sick, and perhaps let folks who have fully compensable cases wait and go on a registry, and if their disease progresses to a certain level, that they then would take advantage of whatever judicial resources were available. And that was sort of contrary to the trends, and it appears that now in your courts, the non-malignancy cases are really not things that get the attention and the judicial resources they used to. And even though I've always been a mesothelioma victim advocate, I never took the theory that if someone has a lesser disease, a smaller disease, a less deadly disease, that he then doesn't have a case. I never understood that logic, and I understand that the problem with the non-malignant cases was that there's too many of them. I think it's just that simple. And the blame for that always gets laid at the law firms who, quote, screen for cases, or they criticize the doctors who make the readings, and I don't even want to wade into that morass. I think the reality is that if you expose 30 million Americans to asbestos, you're going to have a lot of disease. And the question I get asked most by judges is, how long will asbestos litigation last? Isn't this something out of the past? And particularly judges who don't get these cases because they may be directed to a single court, they, like even jurors, are surprised to hear, wasn't this wound up long ago? Isn't this an historical fact? Well, the reality is that asbestos is still legal in this country. They still use it in some products. And one of the reasons, much of what Bill talked about with the friction cases, is why are the cases involving brake linings, why are they so hot now? Well, the simple answer is that asbestos was used in brakes in this country, is still used in brakes in some applications in this country, and was widely used into the 2000s. So the theory that asbestos was banned when EPA came out in 1972 just isn't the case. And in terms of the low dose theory, and if you've been in this long enough, you hear every theory go around and come back again. But the terms that I hear most now are that from any particular lawyer representing a defendant is that we need to make sure that exposures that are trivial or de minimis or peripheral, the peripheral defendant theory, that those exposures simply should be excluded from the equation, that they have no liability. Well, when I look at it, ones that are trivial and de minimis and peripheral are always my defendant. Of course it's trivial. I represent this company. Of course it's peripheral. He's my client. And the imagery I tend to use is about someone, and the guys I represent are typically pipe fitters or insulators, and since it's mesothelioma, it doesn't necessarily have to be some guy who was knee-deep in asbestos his whole life. Sadly, the opposite is true. It's almost counterintuitive. The less serious diseases require a lot more exposure. The most serious diseases require exposure to asbestos and very bad luck. And maybe I can anecdotally tell you why I think in every level that's true. Some of the earliest clients we represented were people who worked at the Johns Manville plant in Waukegan. Now, this plant was knee-deep in crucidolite asbestos, and people worked there for 30 and 40 years. And the good news is that many of them never got mesothelioma. They stood in this as long as you could. By the same token, I represent people the example that I guess is the closest is a lawyer in this city who was always a white-collar worker, except for one summer. He worked at the Manville plant in Waukegan, and he got mesothelioma. So it didn't matter to him that he didn't meet the profile, and most mesothelioma victims don't meet the profile. But the low-dose exposure defense is always that my clients' exposures were not important. Well, if you follow that logical syllogism, here's what happens in the real world. You're a tradesman. You work and you are exposed to, pick a number, 50 individual companies' asbestos, or 100 companies' exposures, everything from insulation to gaskets to packing. The application and the number of ways asbestos was used is really remarkable. And the more you dig into it, and if you spent your life in this arena, you can't believe how much asbestos is used, where it's used, and some of the products it's used in. But the logical syllogism that gets advanced, and which was so competently advanced here, is that this wasn't the gaskets, this was the insulation, this was somebody else. In fact, if you take it to the end, if there are 100 individual defendants in a case, and that's overstating it because there just aren't usually, typically it's more like 20, but if there are 100, and each of them, let's say, had an equal exposure profile, well, there's 100 individual companies that exposed my client. He got mesothelioma. Isn't every one de minimis? Isn't every one trivial? Isn't every one unimportant? Well, my guy and the families of my guy don't think they're unimportant. They don't think they're trivial, and they don't think they're de minimis. But I could certainly make the argument, as I get that argument every day in court, Judge, we were just one little guy. We were just one piece of the puzzle. And an even more effective argument is not just that I want to tell you whose asbestos caused it because it wasn't mine. It's the defense of everybody else's asbestos caused my client's mesothelioma. You take all 99 others who settled out, Judge, and paid money to this client. They killed him. They caused his exposure. They caused his mesothelioma. My client's is so little, so unimportant. Well, then I suppose the answer is that if everyone can make that argument and everyone is true, that no one's exposures caused my client's mesothelioma. And to simply dismiss the concept of fiber burden in mesothelioma development is just not scientifically appropriate. And I would caution judges to be very careful about using non-asbestos, non-mesothelioma cases to support that theory. And I often am faced by many trial judges, and we have some of the greatest trial judges in the world in Chicago, and you never want to say to a judge, asbestos is different, or mesothelioma is different, because they come from a background where, what do you mean? It's a case, it's a trial. I understand evidence, there's nothing different about it. Well, there are some differences, and there's certainly some differences with mesothelioma science from other diseases. And the fiber burden, and whatever analogy is, whether it's the Washington Redskins, and we who live in this city with the Chicago Bears over the last several weeks have some affinity for that problem. But the fact that the exposures combine to cause the man's mesothelioma is accepted by everyone. And the flip side of this argument is one that's what's addressed all the time in our courts, where the defense expert will come in and say, this man has idiopathic mesothelioma. I've been trying to figure out for a long time what that means. And what apparently comes down to is we don't understand, or we don't know whose asbestos caused this man's mesothelioma. Well, simply because it's either unknowable or I can't convince you whose asbestos caused it. It doesn't mean it's idiopathic. And we are over and over presented with experts that come in and testify that a man's mesothelioma is idiopathic. And we found, just simply by cooperating with other firms around the nation, that the experts that were doing it, one guy out of St. Louis in particular, on cases that involved asbestos insulators, shipyard workers, brake mechanics, people that have such a clear pattern of exposure to asbestos that the idiopathic side of this just was not supportable. Mesothelioma is caused by exposure to asbestos and bad luck. It is not caused by, as has been presented in courts in cases I've tried, table salt, red wine, dusty roads. Those literally have been advanced as causes of mesothelioma. To my knowledge, the only cause of asbestos other than asbestos, of meso other than asbestos, is a mineral in Turkey called aragonite, which really doesn't come into play very often. But on the issue of some of the decisions that come out about substantial contributing factor, I'm nothing if not current. The most recent opinion, because Bill talked a lot about the Gregg case in Pennsylvania, is a case called Hicks versus Dana, which was filed November 18th, 2009. And it involves, Dana is a gasket manufacturer in this country, that their defense is always, we have this encapsulated product, it's pristine, it's a little gasket, it's surrounded by things like polyurethane or rubber, and the fibers don't get to the men. Well, I've represented a lot of pipe fitters and a lot of guys with meso, and I believe in my soul that the fibers get to the man, but regardless of that, these gaskets don't simply remain the way they can show you a picture in court. By the time they take these things out, they look like a piece of garbage. They fit between two flanges of pipes. They're falling apart. And you go in there with wire brushes and chisels and hack them out and breathe the fiber. Remember, if you visibly see dust, if you visibly see asbestos dust, you are far above any acceptable level that's ever occurred in this country, what they call the threshold limit values, the TLVs. If you can see it, you're above it. And the imagery I often use is when people say, how do these people get this disease? Anybody who's ever been in a room with sunlight streaming it into, and with the best housekeeping in the world, if you hit the sofa, you see those fibers flying around in the room. And unfortunately, it's the littlest ones that are the most dangerous. And when you see those fibers floating around them, that's how people breathe this stuff in. But when you're taking a gasket and you're breaking it up with a chisel and brushing it off with a wire brush, that's all you see. And that's what you do, and that's what these guys did. For 30 and 40 years, they went to work, they breathed asbestos, and some of the unlucky ones got mesothelioma. But the Hicks case was based upon a trial court verdict in Philadelphia, I think for $5 million against John Crane, who's a manufacturer, and against Dana, who's a manufacturer of these non-deadly gaskets. And when they did the appellate decision, they actually reheard it en banc in just, I commend it to your reading. It is 71 pages about these very issues. And what they talked about the substantial factor test, and since they quoted a case of mine, I just assumed that they were right on the issue. But the case that they quoted is called Tragars versus Keene. And it is a case from 1992. And it is by the Circuit Court of Appeals in the Seventh Circuit, which is not perceived as some bastion of liberalism or some bastion of pro-plaintiff decisions. But when the court in Tragars, and which is now quoted in Hicks, which talks about Gregg, which is the case that counsel talked about, said that the substantial factor test is not concerned with the quantity of the injury-producing agent or the force, but rather with its legal significance. Defendants in every court I want to come into want to talk to you about, it was little, it was small, they want to quantify it, such as is required in the Flores decision. And they want to literally have somebody say it was, 2% of my total exposure over my lifetime. Well, what the court said in Tragars 20 years ago, and what the court said last week in Pennsylvania, is that where there is competent evidence that one, and they use these words, that one or a de minimis number of asbestos fibers can cause injury, a jury may conclude that the fibers were a substantial factor in causing the plaintiff's injury. This is not some doctor. This isn't Sam Hammer. This is the en banc Pennsylvania Appellate Court commenting on the Gregg case. So the question isn't whether or not it's that somebody's opinion is that it's little. The point is whether or not it has a legal significance in the cause of the disease. And since we know from the science that mesothelioma, sadly, gets caused by low-dose exposures, that's the analysis to do. One of the frustrations we have all the time is that having shown and being held to a standard of proof to prove these exposures, the flip side is not enforced. In other words, that when the trial defendant makes the argument that it wasn't my asbestos, it was somebody else's asbestos, they don't have to come in the same fashion and prove those asbestos exposures, because it's difficult for them to do. They'd have to go find coworkers, they'd have to find clients, but rather they said, the man was an insulator, the man was a carpenter. Of course he was exposed throughout his whole career to asbestos fibers. Well, that gets very fuzzy in court sometimes, because I assume what's good for the goose is good for the gander, and if I've got to prove the exposure to the trial defendant, they better be held to the same standard to prove this other individual, this other company who caused the exposures. I wanted to take at least some time to not just talk about substantial contributing factor, because, as I say, I think most of the courts, you just don't, not all of you get asbestos cases, and maybe perhaps some of you say, I don't want any asbestos cases. They take forever, they're very boring, they're very repetitive. Those of us who do it all the time really don't find it all that boring, oddly enough, even after all these years. But my last point on substantial contributing factor is that if you stay in this long enough, you find that things come around. Back in the day, which was described, cases when they were tried 20 years ago, the arguments that the defendants argue against now were actually made by them as some of their best arguments. They used to advance the single fiber theory. They used to say that on a subcellular level, mesothelioma is caused by exposure and respiration of one bad, unlucky, vicious fiber. They used to call it the magic fiber theory. And you'd think, why would they be arguing that only one fiber could cause this? Well, here's the way the argument went, and I'm not supposed to say who made the argument, but their name rhymes with Owens, Illinois. And they would say, well, if only one fiber of billions of fibers represented by this man caused his disease, then you, Cooney, you can't prove which one, and you lose. You're not able to show which was the implicated fiber. Now, we brought in everyone from W.T. Elliott McCaughey, who was the head of the Canadian U.S. Mesothelioma Board, the world's most recognized expert in mesothelioma, who said, it's not some magic fiber, it is the burden of the fibers that has an impact on the person's physiology and lungs and ultimately results in him having this disease. And people get very passionate about it. Companies involve lots of money. I've represented several thousand mesothelioma victims. Not one has ever survived. So that when these arguments go back and forth about why this is important, the passion is obvious. You guys see it in court all the time, and we try to excuse ourselves for it, but it's hard to do. So what is the future? Well, here's what I think the future is. I think that you will be seeing a lot less asbestos cases. No matter if you will practice in the field, you don't practice in the field, you may anticipate seeing it. You're not going to see non-malignant cases on large scales. It has nothing to do with the fact that there aren't non-malignant cases. It has everything to do with the fact that Bill and others have been successful in advocacy in state legislatures and have passed statutes that require that these cases either wait or that they simply can't be brought. And it was one area in which I guess we aligned philosophically, that I think at least the non-malignant cases, the unimpaired non-malignant cases, ought to defer to the more serious cases in terms of time. But you in your courts will see less of them. I think you will see a lot, we've already seen a lot more vigorous litigation of the mesothelioma cases. I think historically those cases literally either got resolved or settled, at numbers that don't make any sense to me. I mean, they would be, relatively numbers in the hundreds of thousands, perhaps $1 million cases would settle for at some point, and then I would compare them to airline crash cases or medical malpractice cases in my own community, and there was just no logical relationship. So the stakes on the value have gone up. The lawyers trying the cases are working them up for every defendant, for every implicated exposure, all the things that he talked about. They're trying to find every piece of the puzzle. I don't understand why that's the wrong thing to do. If a company's product, if he was not exposed to their product, I get it. But when they were, that's a different scenario. And one of the problems just of the time period and the latency of the disease, when time passes, you can't find every exposure. It just isn't possible. Is that red light bad for me?
You know what? You take a few more minutes if you
All
want.
right,
We'll
okay.
we've got plenty of time, so we're in good shape.
But I think the feeling when I talk to people who just simply are bombarded with very boring commercials about this word mesothelioma, and they say, what is this stuff, and why are people advertising on television for it? And my father was a trial lawyer, I'm one, and I'm not critical of that, I just find it tacky. But the truth of the matter is that there are more commercials on television for mesothelioma than there are mesothelioma cases. There are 2,800 mesothelioma cases diagnosed in this country every year. The epidemiologists tell me that this curve will come down and that there will be less. For better or worse, I'm not seeing that. If it's happening slowly. There are about the same number of cases that there have always been. The pathology and the diagnosis is actually better now, and I think more cases are diagnosed as mesothelioma that used to be just buried as lung cancer cases, depending upon where you got your medical treatment. I think they're identified, and therefore there's probably a higher identification where the disease becomes a case. Just parenthetically, I think that there's some interesting trends about whether or not non-U.S. mesothelioma cases will be brought in this country. The jurisprudence in New Jersey suggests that that's doable, and Delaware as well. Just to give some analysis to torture the analogy of a burden, while there are 2,800 mesothelioma cases diagnosed in the United States, there are more mesothelioma cases diagnosed in the Netherlands than there are in the United States. Not on a per capita basis, but on an absolute basis. The products from American companies were shipped all over the world. There are the estimates in terms of some of the impact. In Canada, within the last week or so, they've identified the largest cause of deaths in the workplace in Canada is asbestos exposures, accounting for, I think, 60% of the deaths in workplace in Canada. I've not seen the American figures, but they may be similar. So I think but on an overall basis, the theory that this is increasing just isn't the case. I had some figures that in terms of what actually gets spent is actually the opposite in terms of what recoveries are out there and what the insurance companies are paying for that. On December 4th, I told you I was nothing if not current and topical, 2009, the Business Insurance Review released the AM Best numbers. And in 2008, the asbestos and environmental losses for the insurance companies are the lowest since 2000, the year 2000. In 2008, the asbestos losses for the carriers are 49.9% lower than 2007. And the decline is the fifth in the last 6 years. They acknowledge that the growing proportion of the resolution and settlements are on the more serious cases, almost exclusively mesothelioma. And they see and also a shift from product liability to non-product claims. I won't go too deeply into that. And I guess the good news for court burdens and judicial resources is that even in non-asbestos, environmental losses for the carriers are down 51.3% in 1 year. So if asbestos recoveries are down almost half, and environmental are down 41.3%, I conclude that there are more serious cases being brought in much lower numbers, much less burdens on the court, but that the stakes will continue to be high and the passions will continue to run high.